Welcome to the Supreme Court Podcast. All opinions expressed in this podcast do not reflect the views of the Supreme Court. For clarity, the text of the decision prevails.
Disputes involving real property are a common problem that many Filipinos face. These disputes can result from various situations involving different people, among neighbors over property boundaries and right-of-way, among family members over land title issues, among tenants and landlords over breach of contract. In the case of Edgar M. Rico versus Ernie Toto Castillo, the Supreme Court weighed in on a conflict where questions of possession, power, and procedure surfaced after a demolition team forcibly entered a piece of land occupied by Rico. What followed was not just a legal contest over the lot property, but a battle over which rules apply and who gets to enforce them. Rico filed a complaint for forcible entry against Ernie Castillo and others, claiming that he was the free patent applicant of an 11,015 square meter property he was previously renting in Barangay Matina, Davao City. Rico anchored his complaint on his claim that the respondents destroyed the steel gate of the property to force their way in and demolish the structures in the premises. Both the Municipal Trial Court in cities and the Regional Trial Court ruled in favor of Rico, recognizing his prior physical possession of the property. But the Court of Appeals reversed these rulings, citing a previous unlawful detainer case where Rico had been ordered to vacate the property in favor of its titled owner, Milagros Villa-Abrile. The Supreme Court, however, disagreed with the Court of Appeals. The Supreme Court stressed that forcible entry cases deal strictly with physical possession and not legal ownership. It added that forcible entry requires only proof of prior physical possession and that ownership may be touched upon only provisionally. Even parties claiming ownership cannot take the law into their own hands. When someone forces their way to take over a piece of real property, how do courts determine who truly has the right to possess the property? Hi, I'm Attorney Mike Navallo, Supreme Court Chief Communications Officer. It's the 28th of November 2025, and today we talk about forcible entry and the rule on summary procedure within the context of the case of Edgar M. Rico versus Ernie Toto Castillo, GR number 215166. The decision was penned by Associate Justice Jose Midas P. Marquez and promulgated by the Court's First Division on July 23, 2024. And joining us today to discuss is Judge Jackie B. Crisologo-Saguisag of Branch 67, Metropolitan Trial Court, Makati City. Judge Jackie is a member of the Remedial Law Department of the Philippine Judicial Academy. She is also a member of the Technical Working Group for the Committee on the Revision of the Rules on Summary Procedure and Small Claims. Hi, Judge Jackie. Welcome to the Supreme Court Podcast, and thank you for inviting us to your office and courtroom with a great view here in Makati City Hall.
Good day, Attorney Mike. Good day, everyone, and welcome to Makati City Hall.
Thanks for having us, Judge. First off, let's try to distinguish between forcible entry and unlawful detainer. How different are these two concepts?
All right. So we have ejectment in general, which refers to forcible entry and unlawful detainer under Rule 70 of the Rules of Court. These actions are aimed at the recovery of possession of real property. But although both are under ejectment, forcible entry and unlawful detainer differ in several key aspects. So for example, for the nature of possession by defendant, in forcible entry, defendant's entry is illegal from the start. The occupant took possession by force, intimidation, threat, strategy, or stealth. In unlawful detainer, on the other hand, defendant's possession was initially lawful but became unlawful upon the expiration or termination of the right to possess. So one example would be a contract of lease that ended. And as to period to file the action for forcible entry, the 1-year period is counted from the date of actual entry or when the plaintiff becomes aware of the forcible entry. In unlawful detainer, the 1-year period is counted from the date of the last demand. So that would be some of the key distinctions between forcible entry and unlawful detainer.
And just to be clear, Judge Jackie, forcible entry is different from mere trespassing into a property.
Oh yes, trespassing is different, first of all, because forcible entry is a civil action. Trespassing is a criminal offense under our revised penal code. So in forcible entry, What is important is for the plaintiff to prove prior physical possession of the property, deprivation of that possession, again, mentioning force, intimidation, threat, strategy, or stealth, and that the action must be filed within 1 year from the alleged dispossession. The focus here is on who had prior physical possession and whether it was taken by force or stealth. Okay? Title or ownership is not essential and may be tackled only provisionally. In trespassing, again, it is a criminal offense under the revised penal code. The prosecution here must prove entry into the property or dwelling of another without the owner's consent. Entry is voluntarily done and without right. There is no need to prove force, stealth, or prior possession, and the focus is on the act of unauthorized entry regardless of the possession disputes.
So there was, in trespassing, you don't really have the trespasser possessing the property. It's enough that he or she entered the property without permission of the owner.
Yes, correct. So in forcible entry, the main focus is again on prior physical possession. That is not essential in trespassing.
Right. And Judge, this distinction between forcible entry and lawful detainer is very relevant in the case of Rico versus Castillo, because one party here resorted to filing an action for forcible entry while the other one filed a complaint for unlawful detainer.
Yes, correct.
So, first, what triggered the action for forcible entry filed by Edgar Rico against Ernie Castillo and Marilu Lopez?
All right. So the forcible entry action here was triggered by Rico's allegation that he had prior physical possession of a portion of the disputed lot as a free patent applicant and occupant. Okay, he was claiming that respondents here illegally entered his portion by destroying a steel gate and demolishing the structures on his property. On the other hand, the unlawful detainer complaint, which was filed by Villa Abrille, that was based on her claim as the registered owner of the lot, and she said that Rico was occupying a portion of her property as a tenant. In fact, they had a lease agreement that was about to expire. And when it expired, she filed the unlawful detainer complaint against Rico.
And this is quite a complicated case, Judge Jackie, because there were some appeals involved. And in the end, Villa Abrille says she won the unlawful detainer complaint in the MTCC, the Court of Appeals, even the Supreme Court. But supposedly, the decision was never enforced. While Rico, on the other hand, also won the forcible entry action before the MTCC and the RTC. But the CA reversed the ruling. So to cut the story short, who actually won here? As between Villa Abrille and Rico, who was right based on the Supreme Court ruling?
All right. So, as you mentioned, there was that unlawful detainer case filed by Villa Abrille, which she won all the way up to the Supreme Court. But then Rico filed a forcible entry complaint against Villa Abrille and Castillo. But in the end, the Supreme Court ruled in favor of Rico. All right? Because under the forcible entry case, the Supreme Court here reinstated the rulings of the first level court and the regional trial court in favor of Rico, and it found that he established prior physical possession. All right. So the Court of Appeals decision that reversed the lower court, the trial court's decision, was reversed as well by the Supreme Court.
So, Judge Jackie, what happened to that unlawful detainer case, which Villa Abrille was claiming that she actually won all the way to the Supreme Court?
Okay, so although Villa Abrille won that unlawful detainer case against Rico, in the end, the Supreme Court found here that there seems to be a problem with respect to the identity of property involved in that unlawful detainer case. So that decision was never enforced, and apparently the reason there is because there is a question whether the disputed portion of the property occupied by Rico was actually part and covered by the lot claimed to be owned by Villa Abrille.
Right. And the Supreme Court also said that the Court of Appeals erred in giving due course to Castillo's petition for certiorari. Supposedly, it was the wrong remedy. What should have been the proper remedy according to the court?
Well, so in this case, the Supreme Court held that the Court of Appeals should not have given due course to the Rule 65 petition for certiorari. The proper remedy was a petition for review under Rule 42 of the Rules of Court. And the court here also, the Supreme Court mentioned that there was no finding of a grave abuse of discretion on the part of the lower court. And what the Court of Appeals did was, in fact, to just substitute its judgment and its evaluation of the facts and evidence as against that of the trial courts.
Right. And what did the Supreme Court say regarding the use of force or self-help in ejecting a possessor, even when the party using force claims to be the rightful owner? So in other words, Judge Jackie, in an unlawful detainer case, can a litigant who has legal title to a property resort to force in removing an opposing party from his or her property instead of applying for a writ of execution?
So the Supreme Court was very emphatic on this matter. No, it stressed that in unlawful detainer case, or generally in possession litigation, the party who holds legal title cannot resort to force or self-help to eject the occupant. We have to remember that ownership or title does not give a party license to physically oust an occupant by force or intimidation. The proper way is by legal enforcement of a court judgment, not self-help. So in the decision, the court observed that even though Villa Abrille may have had the title, that fact alone did not permit resort to forcible entry or self-help. For forcible entry, the focus is prior possession, and the court reiterated that it is only that, the prior physical possession, which is relevant in this case.
Right. So, just this is really a good reminder to our listeners that even if you hold title to a property, you cannot just eject those who are in physical possession of the property. You have to go through the court process, and it's very relevant that our listeners know about the whole process. Understand we had the 1991 revised rule on summary procedure, and we also have the 2016 revised rules on small claims, which were revised in the past few years, specifically in March 2022. And you were part of the technical working group for the revision of these rules. So it's now called the Rules on Expedited Procedures in First Level Courts. What are some of the significant changes in the revisions that you proposed?
So just a brief background on these rules. So the original revised rule on summary procedure and procedure for small claims were promulgated way back in 1991 and 2010, respectively, as you mentioned. But since then, the threshold amounts for summary and small claims cases have increased throughout the years. So, for instance, in small claims, we started with 100,000,
Right.
then 200,000, and then it became 400,000. At the same time, the jurisdictional threshold for the first level courts was also steadily increasing. In 2021, Congress passed Republic Act 11576. Now, with this law, the first level courts now have jurisdiction over all civil actions, probate proceedings, admiralty, and maritime cases where the value of the claim does not exceed 2 million pesos. For actions involving title to or possession of real property, first level courts now have jurisdiction where the assessed value does not exceed 400,000. So this is for civil cases. Meantime, for criminal cases, the jurisdictional thresholds also increased by virtue of Republic Act 10951. Because of all these developments, the overlapping threshold amounts, there was clearly a need to adjust and recalibrate the rules.
Right.
Okay, so this is why the Supreme Court promulgated the Rules on Expedited Procedures, which took effect on April 11, 2022. So to be clear, these rules consist of the applicable procedures in summary cases and small claims cases in all first level courts. So this time we have adjusted all the threshold amounts so that there is no conflict. Okay. What are the objectives of the Rules on Expedited Procedures? Aside from harmonizing and updating, the Supreme Court wants the procedures to be more accessible to lawyers and litigants, simpler, more user-friendly. The court wants to improve and equalize access to justice, declog the court dockets, eliminate inefficiencies, and prevent abuse of court processes. How do we do this? For example, in summary cases, we have an enumeration of prohibited pleadings and motions. A motion to dismiss in summary civil cases is prohibited except on the ground of lack of jurisdiction over the subject matter or failure to comply with the requirement of barangay conciliation. Dilatory motions for postponement are prohibited unless grounded on acts of God, force majeure, physical inability of a counsel or witness to appear. And another example is a motion to admit late judicial affidavits except on the ground of force majeure or acts of God. So the rules make it more difficult for delays to happen during the court proceedings. So we are trying to minimize and, if possible, remove altogether the causes of delays. It is also important to note that the rules recognize and utilize the technological advancements over the years. So electronic service is specifically mentioned in the rules. Service can be done by electronic means like email or fax. This is very helpful for the courts and the parties as we need not rely on registered mail. We also have provisions on video conferencing. This is specific to the rules on expedited procedures. Just a few years ago, something like this would have been far-fetched for us, but the pandemic forced us to be more creative and resourceful. We have VCH now. And it may be done upon initiative of the court or upon motion. In summary cases, the court-prescribed platform may be used, which as of now we have the Microsoft 365. In small claims cases, subject to certain conditions, the court even allows other platforms like Messenger, Viber,
SMS,
WhatsApp, SMS. In sum, the promulgation of these rules is in line with the Strategic Plan for Judicial Innovations, or what the Supreme Court refers to as SPJI, which is spearheaded by no less than our Chief Justice. And the goal really is to deliver responsive and real-time justice for all.
So in short, to make it faster, the whole procedure.
Yes.
Right? In terms of timeline, Judge Jack, are we looking at shorter, maybe shorter trial periods for summary procedure?
Yes, in fact, in summary cases, civil cases, we don't have trial at all. So that's really a shorter period for resolving cases. And we are much stricter, as I've mentioned, for the delays and motions. The court is allowed to be more strict in the imposition of these deadlines and timelines.
So what's our time frame with respect to, say, civil or criminal cases under the revised summary procedure?
So for summary civil cases, our timeline would be about 6 months. The summons, upon filing of the complaint, the summons is issued and the defendant is given 30 days to file an answer. And then after that, we have our preliminary conference. We call it preliminary conference because in summary civil cases, we do not have trial anymore. But during the preliminary conference, the case can actually be submitted for decision right there and then. So with that, no trial, 6 months, we can finish summary civil cases.
And that's quicker compared to the previous time frame that we have, Judge Jackie.
Well, the one significant change of the rule on summary procedure in civil cases right now under the expedited procedures is that the submission of position papers is no longer mandatory. So that removes a big chunk of time from our flow chart for civil cases. So yes, there is significant change in my opinion.
Right. And one aspect of this, Judge Jackie, is under the rules on expedited procedures, civil cases covered by the rule on summary procedure, which now consist of forcible entry and lawful detainer cases, among others, there's a limit here on the issues in forcible entry to just prior physical possession. Is there a logic to this? Is there wisdom why it should just be limited to prior physical possession?
Well, ejectment actions are designed to address immediate issues of who has the right to occupy a property. So the focus is on possession rather than ownership. That is intentional. The distinction is crucial because ownership disputes often require more extensive evidence and legal arguments, which could delay the process, which is why the recovery of ownership falls under regular rules of procedure and not the rule on summary procedure. Limiting the scope to physical possession simplifies the proceedings and minimizes the need for complicated legal arguments about ownership rights, so that it makes it easier for the parties to present their cases and for the courts to make quick decisions.
Because unlike in determining the title, for example, who really has ownership, you go into the whole history of how you occupied the land. You have to have evidence presented and even witnesses.
Oh yes.
Right. And that takes a lot of time.
The issues are much more complicated when ownership disputes.
So what would be the effect if the court finds that the case should have been one for forcible entry, but the complaint was lodged as an ordinary civil action for recovery of ownership? Will it affect the jurisdiction of courts, and what would be the procedure to be followed?
Well, the effect would be ultimately the case would be dismissed because there are different requirements for ejectment cases as opposed to actions for recovery of ownership. There will be an effect as well on jurisdiction because under Republic Act 11576, the first level courts have jurisdiction over civil actions involving title to or possession of real property where the assessed value does not exceed 400,000 pesos. Beyond that, it would be the regional trial court, which has jurisdiction.
All right, so Judge Jackie, just maybe to close our discussion, what's a good takeaway that our listeners can keep in mind, especially those who are not so learned about the law? I mean, what do they need to remember in case they find themselves in a situation where they need to file maybe an action for forcible entry or unlawful detainer? They don't know exactly what to do, or if they find themselves at the receiving end of those cases.
First of all, they have to be aware of the distinction between forcible entry and unlawful detainer. As we discussed earlier, they are both with respect to possession of property, but very different circumstances. So they have to be aware of the specific situation and the proper action that they should file applicable to their situation. And also, they have to remember that while we have the rule on summary procedure, which provides a more expeditious process for resolving disputes, we must not take the law into our own hands. No matter how tempting it may be, the laws and procedures are there for us to have an orderly dispensation of justice, and so we must follow them and avail ourselves of the proper remedies.
All right, take it from Judge Jackie. Thank you so much, Judge Jackie, for joining us today.
Thank you very much, Attorney Mike. Thank you very much to everyone here from the Public Information Office.
And if you wish to read the full text of the decision we discussed today, please visit the Supreme Court website and e-library and search for Edgar M. Rico versus Ernie Toto Castillo, GR number 215166. Here's Steph Atendido Beltran, Supreme Court Information Officer, for this week's updates.
From the Supreme Court of the Philippines, here's the latest. Associate Justice Ramon Paul Hernando, on Thursday, November 27, led the groundbreaking ceremony for the construction of a new Butuan City Judicial Complex at Barangay Tiniwisan, Butuan City, Agusan del Norte. Speaking in front of local officials, Justice Hernando emphasized that a strong judicial system is one of the essential drivers of further growth of a locality. He also led the inauguration of 2 courts in Cabadbaran City, housed at the Agusan del Norte Capital Annex building, where he expressed hope that the new facilities will open the way for a deeper sense of duty, unity, and compassion in the delivery of justice. In the afternoon, he spoke about the Unified Legal Assistance Service, or ULAS, and held a dialogue with judges, lawyers, court personnel, and law students at a forum organized by the Father Saturnino Urios University, the Integrated Bar of the Philippines Agusan del Norte, the City Government of Butuan, and the Office of the Regional Court Manager of Judicial Region 10. During the forum, SC Chief Communications Officer, Attorney Michael Jobert Navallo, provided updates on key projects under the Strategic Plan for Judicial Innovations, or SPJI, the SC's blueprint of action for reforms. Justice Hernando also met with Judge Janice Ivy Valparaiso Chua, Regional Court Manager Region 10, and judges of Agusan del Norte and Agusan del Sur on Wednesday. Justice Hernando is the chair of the SC Oversight Committee over the general maintenance of the Philippine Halls of Justice. The Supreme Court has ruled that voluntary arbitrators have jurisdiction over a labor dispute only when both parties clearly and mutually agree to it. In a decision written by Senior Associate Justice Marvic M.B.F. Leonin, the SC Second Division ruled that a panel of voluntary arbitrators lacked authority to resolve the monetary claims of Benji Tandayag, A.C. Ferrer, against Magsaysay Maritime Corporation. Instead, the jurisdiction over the dispute lies with the labor arbiter. Under the Labor Code, money claims arising from employer-employee relations must be filed before the labor arbiter, a rule similarly stated in RA 8042 or the Migrant Workers and Overseas Filipinos Act for claims of overseas Filipino workers. Voluntary arbitrators, on the other hand, handle disputes involving collective bargaining agreements or CBAs, company policies, and other matters that both parties agree to submit to them. The Supreme Court noted that there was no collective bargaining agreement and that the corporation promptly insisted that the case belonged to the labor arbiter. The Supreme Court has reiterated its call to ending violence against women, or VOW, as it joins the annual 18-day campaign to end VOW. At the kickoff activity on Monday, November 24, Chief Justice Alexander Hismundo emphasized the need for a whole-of-nation approach in ending VOW. He said members of the judiciary can contribute to this end by ensuring fair, firm, and swift implementation of laws, protecting women, advocating for continuous gender sensitivity training, being more proactive in mainstreaming gender sensitivity in the legal profession, and fostering a culture of collaboration to promote awareness and preventive measures against VOW. He also commended the SC Committee on Gender Responsiveness in the judiciary's efforts, chaired by Associate Justices Henry John Paul Inting, Josep Lopez, and Maria Filomena Singh. Acknowledging that VOW is still a painful reality, Justice Inting encouraged trial courts to prioritize cases involving women and children. For his part, Justice Lopez stressed the judiciary's commitment to advancing gender equality through progressive jurisprudence, policy reforms, and capacity building. This year's campaign runs from November 25 to December 12, 2025. Associate Justice Maria Filomena Singh on Friday, November 21, highlighted the Supreme Court's integrity reforms at the 10th anniversary of the Justice Reform Initiative in Makati. Justice Singh cited the approval of the 2025 Code of Judicial Conduct and Accountability and the 2025 Code of Conduct and Accountability for court officials and personnel, which completes the SC's integrity initiatives following the passage of the 2023 Code of Professional Responsibility and Accountability for lawyers. The Supreme Court also reorganized the Judicial Integrity Board into the Judicial Integrity Office. In 2024, the SC penalized 42 trial court judges, while 166 lawyers and 109 court personnel were administratively punished. Justice Singh stressed that to fight corruption, the judiciary must uphold transparency and accountability and ensure an ethical climate that supports institutional reputation. Formed in 2015, the Justice Reform Initiative is a venue for collaboration between business leaders, advocacy groups, and civil society organizations in promoting justice reforms. Meanwhile, on Tuesday, the Judicial and Bar Council, or JBC, announced the opening for application of the positions of Court of Tax Appeals Associate Justice to replace Honorable Catherine Manahan, who will mandatorily retire on January 2, 2026, and Sandigan Bayan Associate Justice Teresa Dolores Gomez Estuesta, who was appointed Court Administrator on September 1, 2025. Interested applicants may submit their applications via the JBC online registration and application system until January 12, 2026. You are now up to date with the Philippine Supreme Court. I am Tifa Tendido Beltran, Supreme Court Information Officer.
And that's our podcast this week. Join us again next time for a detailed discussion of select cases decided by the Supreme Court. I'm Attorney Mike Navallo, your Supreme Court Chief Communications Officer. You can catch this podcast as well as previous episodes on the Supreme Court Public Information Office's accounts on Facebook, YouTube, Spotify, and Apple Podcast. This podcast episode was produced by the Supreme Court Public Information Office, with Attorney Mike Navallo as overall in charge of production, Attorney Karen Martinez as supervising producer, J. Rempilio, executive producer, Tifa Tendido Beltran, producer, May Sibal, Attorney Ian Aldueso, Attorney Sheila Reyes, and Ramir Simbahon as researchers and writers, Brian Austria, Don Ryan Balza, and Vini Laranio as audio editors, Lawrence Olanyo and Austin Aliscad as video editors, Bea Batong as graphic artist, and Tyke Flores and Jerome Batumalaki as web editors.